Any of you watched the Illinois Supreme Court hearing on the Safety Act yesterday? Good morning, Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk, and that's where we're going to start talking about no cash bail and the Illinois Supreme Court taking up that suspended law and the oral arguments from the states and from the plaintiffs and the state's attorneys and sheriffs across the state that sued to block this from being implemented on January 1st. And last fall, they advanced their lawsuit regardless of the state legislature passing amendments to no cash bail to increase the net of detainable offenses and to tweak things. Regardless of that, they advanced their lawsuit in Kankakee County. You had 60-plus counties involved there. And ultimately, the Kankakee County judge finding that the law violated the Constitution on separation of powers, but also the Victims' Bill of Rights. These were issues that were debated in detail yesterday at the Illinois Supreme Court. We're not going to be able to touch on every single one of those points. I mean, it was a 45-minute hearing where you had the states present their case, you had the plaintiffs present their case, and that was all peppered throughout by state Supreme Court justices. And you had an entire bench on there, all 7 justices on that bench, and that is some people looking to see if 2 of those justices would have recused themselves from the hearing because they each got $1 million from Governor J.B. Pritzker, who was a top defendant in the case. Yes, as a governor, not as an individual, but still, that's raised the issue of possible impropriety. And as we've heard before, any issue of that that could breed a question of conflict of interest, it means that there is a conflict of interest there. Even just the perception of it can mean that there's a conflict of interest there. So a lot of you have pointed that out and asked those substantial questions. But let's go ahead and get into this because, of course, you've got the case has been taken under advisement, meaning that the Illinois Supreme Court is going to deliberate this before they actually issue a ruling, and it could be weeks before we have a ruling in this case. But let's go ahead and hear some of what the Illinois Supreme Court had to say yesterday, and we'll start with the questioning right up front, where the Supreme Court Justice Lisa Holder White, she didn't hesitate to start questioning the Deputy Solicitor General Alex Hemmer for the state of Illinois.
The Circuit Court reasoned that 2 separate provisions of Article 1, Section 9, which we call the Bail Clause, and Section 8.1, which we call the Crime Victims' Rights Clause, each independently require the state to maintain the institution of monetary bail. That reading of both clauses is wrong.
Counsel, I have a question. In the past, we've seen where changes have been made with respect to who is entitled to bail made through constitutional amendments. Why didn't that happen here, and should it have?
No, Your Honor, it should not have. The General Assembly was not required to put these changes to the voters in a constitutional referendum. And that's for essentially 2 reasons. So the bail clause, the plaintiff's first argument is about the meaning of the bail clause. They say that the bail clause had to have been amended in order to do this. That clause provides that, quote, all persons shall be bailable by sufficient sureties, subject to several exceptions. That clause grants criminal defendants a qualified right to seek pretrial release. It makes them bailable. It doesn't require the state to maintain any particular method of obtaining pretrial release, including the system of monetary bail. The elimination of monetary bail is thus consistent with the bail clause because it safeguards defendants' right to seek pretrial release.
So the Safety Act did not amend the Constitution?
No, it did not.
Neville.
Plaintiff's main argument on that point is that the Act amended several statutory provisions that have the same terms as the Constitution. But of course, the General Assembly is entitled to amend its statutes. The General Assembly didn't purport to amend the Constitution because it didn't need to. The Constitution does not constrain the General Assembly in the way that plaintiffs suggest.
So that's one of the key arguments there that plaintiffs have raised, and we'll actually hear from one of the plaintiffs' attorneys, Kankakee County State's Attorney Jim Rowe, and that is that if they wanted to change bail, if they wanted to address the issues that are protected by separation of powers, they should have done a constitutional amendment. And that's exactly what Jim Rowe brought up yesterday during oral arguments in front of the Illinois Supreme Court. Here is the Kankakee County State's Attorney who brought the lawsuit against the Pretrial Fairness Act.
This court found that if we are regulated by the act, we are a proper party to that litigation. And plaintiff state's attorneys and sheriffs are certainly regulated under that act.
And you are adversely, what is the language of the case? Adversely, there's an adverse
Chief
impact
Justice
on your rights.
Mary Jane Teese.
There absolutely is, as the circuit court found. State's attorneys, prosecutors have an inherent interest in ensuring that we can move cases through the court system, that we can secure a defendant's appearance at trial. The sheriff has an inherent interest.
Why don't you continue to have that right?
I'm sorry?
Why don't you continue to have that right? If you say it's a right, a constitutional right, I'm not sure, but you say you have a right to ensure that defendants appear, to continue to appear. Doesn't that continue under this act?
Well, the act abolishes the opportunity for a state's attorney to even request a monetary bail as a sufficient surety. And for the sheriff has to ensure effectively the safety of every law enforcement officer under his charge. This act requires them to serve, for instance, notice to appear and then a warrant on 2 occasions. We've now doubled the number of instances where law enforcement is going to come into contact with perhaps a fugitive or a very dangerous individual. So plaintiffs squarely believe that prosecutors and sheriffs have standing to pursue these matters. And the simple way for the legislature to accomplish all of these reforms, take the question, put it on a ballot, propose it to the people, let them vote on it at an election. It quite simply is that easy. And this court, in the Supreme Court Commission report, identified 2 such examples of where that actually occurred. New Jersey and New Mexico. In both of those states, they accomplished comprehensive and significant bail reform, but they did it through the amendment process. They let the residents of their state have a say. They made sure that they followed the will of the people.
So again, it's the plaintiff's lead attorney, Jim Rowe, out of Kankakee County, the state's attorney, making points that he says are clearly a direction the state should have gone if they wanted to cross over into not equal protections, but separation of powers, if they wanted to take over some of the functions of the courts when it comes to determining bail and how a criminal defendant before trial should be released, then they should have gone to the voters to change the state constitution. But that did not happen. What happened was instead, in a few days, you had some shell bills moving back and forth, and I think the original measure passed the Illinois Senate at like 3 o'clock in the morning one morning, and then it got kicked over to the House on the final day of the previous legislature back in January of 2021, and then it passed. Then you had a couple of changes throughout, including last-minute change in the fall, but that didn't keep the state's attorneys from moving forward with their lawsuit. So those are just some of the brief highlights. Again, the brief highlights. Somebody pointing out on YouTube that it only took days to draft the law, but now it may take, days? I would say it's going to take even weeks. It's going to take weeks for this to be dealt with by the Illinois Supreme Court as they took the issue under advisement. Coming back, we will air Governor J.B. Pritzker, what he had to say after watching a few little bits of the trial, but also we'll hear from the bail coalition, which I talked to yesterday, and also just dip back into the question of judicial integrity. So stay tuned. That's coming up here on WMAY. It's now 6:19. You can always chime in live and local, 217-629-7970. That's the phone number. If you want to get your voice heard, again, 217-629-7970. That's the phone number here on WMAY, live and local. But if you're watching on this restream, you can always find me, Bishop on Air, Twitter, Facebook, YouTube, or email, bishoponair@gmail.com. Talking about the Illinois Supreme Court hearing of the no cash bail provision of the Safety Act, which is also known as the Pretrial Fairness Act. And really what it would do is it would, essentially end cash bail as the standard across the state. And this is for people who aren't convicted of a crime. You're innocent until proven guilty, but this is for people who are arrested in the commission of a crime or suspects of a crime that may have to wait behind the county jail walls to wait a trial. Sometimes people can afford bail, others can't. But you also have the questions of how this is going to be implemented ultimately. Governor J.B. Pritzker asked about this after the hearing yesterday. Here's what the governor had to say about the hearing and his confidence levels of the Supreme Court's upholding the no cash bail provision.
I watched a little portion of the proceedings at the Supreme Court as I was driving down here, and it was fascinating to listen to both sides. It's clear to me that there's one side that has the much better argument on the Safety Act, and I think that will prevail. So that's what I can say about that. Well, bail isn't a deterrent. Bail is something that happens after somebody commits the crime. So what I think many sheriffs are concerned about, and I think we should talk about this, is the dollars that they used to be able to collect, or that they would be able to collect with bail, they have been, that they won't be able to collect locally to cover costs at their sheriff's offices. I think that's a not unreasonable thing for us all to be discussing going forward. But that's not a reason to oppose the Safety Act. And so my view is the Safety Act is actually keeping people much safer. What's it doing? Keeping violent criminals in jail, not allowing them to have bail, but taking nonviolent criminals and saying that there's no reason for us to have to pay for you to sit in jail when you can't afford the few $100s to get out of jail. And the reality is you're not a danger to the community. That will be something decided by judges, I might add. It's not the legislature deciding whether someone would stay in jail or not. It's judges who would make those decisions. And I think that's the right way for us to do it. It's a more fair system than to have people sitting in jail for weeks, days, weeks, or months when they just don't happen to have the few $100s or a couple of $1,000, again, when they've committed a nonviolent crime, to be let out.
So those who oppose ending cash bail say judges already have that discretion. We talked with Jeff Clayton from American Bail Coalition yesterday before the hearing, but I'm sure he still feels this way now. He says that, listen, judges already had that discretion, and all this ending cash bail is going to do is increase criminal behavior.
Are first-timers who can't afford bail stuck in jail? Generally not. And I think Illinois being a progressive state, we've already seen that those people just don't exist. And that's exactly what we saw in New York. Laws like this benefit recidivist defendants.
So Clayton saying that he also believes that they should have gone to the Illinois Constitution to change this and not have the legislature do this because of the separation of powers argument. But then we get to the full panel of justices there. All 7 were in the room during the debate on this. Governor J.B. Pritzker being a top donor to 2 of them, as is House Speaker Emanuel Chris Welch, who was also in the audience and a chief defendant in this case, giving to 2 of these Supreme Court justices. All 7 of those justices took part, including the 2 that got the campaign donations from Speaker Welch and from Governor J.B. Pritzker. Just to revisit, the idea of any inkling of impropriety. Chris Forsyth, he is with the Judicial Integrity Project out of Colorado. He shared how that's important to keep that in mind.
And if the public perceives that there's an impropriety, then there is an impropriety, and it should be rectified.
How is that rectified? Through possible recusals. But as we heard and saw last week, Governor J.B. Pritzker writing that idea off as, quote, ridiculous. So we'll see what happens. Of course, with the no cash bail provision of the Safety Act, it could be weeks before the Supreme Court actually decides on that. But we've got an indication of if these justices are going to be on the panel when they take up the gun ban legislation as well. That's going to be in front of the Illinois Supreme Court come May.